I do have limitations of saying within the confines of your own home, but that is where we started. That is where the initial query raised, and I supported that. But when you start dealing with private property, Mr. President, I want to make reference to the Leader of the Opposition and use his language when he was speaking on the Glenderry vesting bill some time ago. He spoke about the way in which in communities, and this is specific to Clause 2, not just the provision of merchandise, selling of merchandise, but also the rendering of services, right? And the Leader of the Opposition spoke at the time about mechanics in communities and what happens when you start to function and provide certain types of services in your communities. Mr. President, I am very familiar at this point with a case which is before the court where an individual functioning in, I believe, St. George North was in the traditional practice of running his mechanic shop from his home. And in this inevitable spillover that takes place, he was initially given oral permission by the owner of the property at the time, who, when the property was sold and passed on to the subsequent owner, that position was not followed through. And he refused over many, many years to remove his derelict vehicles from the people's property. There are now, as I speak, Mr. President, about 3 parcels of land owned by 3 different people who are all caught up in court cases, not just because they are unable to get this individual who is claiming traditional use of the property, even though there are multiple notices asking him to cease and desist. But he is now filing for adverse possession of the sections of the people's land on which he had previously run his mechanic business. So you have people who cannot construct their homes. So when you start creating this notion of vending in residential areas and use of private property beyond your own home, you're going down a slippery slope that does not only perhaps empower the individual, but it disenfranchises other people in the immediate environs of the peaceful enjoyment of their own property. And we have to find that balance that we spoke about earlier. We have to find that balance.
I think that Minister Cummins has pointed us in the correct direction. Deputy Chief, please proceed on the basis of the first proposition, which would be within the curtilage of one's home.
So one's home as opposed to private property.
Well, yes, as opposed to private property.
Thank you.
Well, Chair, I think you should, I believe that should be checked thoroughly and perhaps come back because my reality of one's private property is really and truly no real different from one's private home. But what it does, it allows you to cast the net further in that you might be my brother and I'm going to allow you to vend from a space next to my house where you will pitch a tent. But it's not your home. So I would want to be careful with the language. And why I'm saying this, look, we have enough legislation to deal with adverse possession and all of that. Those things work themselves out. And the owner of a property who does not agree to someone pitching a tent and vending from there should take the necessary action in the first place.
Let me just remind you, Minister, though, that because I don't think we're at odds on this. I think that the language that I had proposed was that we were doing this within the curtilage of an occupied home. Was that not the language?
Chair, it was the curtilage of one's home. It didn't speak to the occupation.
Well, I would wish to I would wish to assume that if it is your home, you're occupying it. Unless we have a different definition of home.
So Chair, that is why I wanted to mainly flag their private property element, which would give the wider scope.
I think that we have to be very cautious about going as far as private property, because that may be a never-ending story. All right?
I don't like false concepts to be accepted easily. Property law is distinct from what we're doing here. Adverse possession is an element of property law. If you occupy a person's land for 10 years or more, and you are uninterrupted, if the body gives you notice, or if there's any contact with the person who purports to be the landowner, then you don't have any case in property law to argue on the grounds of adverse possession. If I see you on my land selling, and I say get off, and I send a letter.
Remember, I am sure that you are right, but that perhaps would not be germane to the.
Well, no, it's
issue
germane
before
because you're talking about property, and it was entertained. And it was entertained, and you know
but
the
it
law.
has not. Though being entertained, it was not the deciding factor behind the decision that was made to proceed.
But it was used as a defense of persons who put in a tray or put in a bench or
I'm urging honourable member that we be mindful of the time. I think we've made progress on the point.
But then I don't want it to limit itself to in the home. Because we are not talking about cases alone in the home. We are talking about cases outside the home, unless the drafters could find a definition for in the home that includes who are outside.
Honourable member, when Ms. Bell presents us with the proposed language next week, we will have an opportunity to revisit this.
Chair.
In an equally robust manner.
Chair, but what was agreed and should not be, what was agreed was the curtilage of the home. That was what was agreed. So that's what you will see.
So, Mr. Chair,
yes.
It means that the point that I substantiated with empirical support, that if you come to Howells Crossroad, you're going to see people selling outside there too. When you come to the Pine, you're going to see another man selling 3. When you come to Mylor's Hill, you're going to see about 3 persons selling. These are not in the homes. There's no way.
No, Honourable Member, they're not. But what we equally have said, and I'm asking you to remember the broad language of the legislation. The legislation is carrying with it a provision for zones. Zones can be created virtually anywhere. The reality is that if we are going to say that you're leaving your place of residence or wherever you go to collect your merchandise, and you then set up at another location, that you are outside of the very useful point that you drew our attention to, which is that some people sell from their house. But outside of their house.
I wasn't the person that made that point.
Where does the first point that you made?
When I made the point, I spoke about people because I had a mental construct of what I witness and endure every day.
Okay.
And that was outside of the homes.
Okay.
But in close proximity, either on their land or land that the owners of the land approve that the person can sell on.
And I'm inviting you to join me at the point where once you're outside of the house, then it allows for the legislation now to creatively create the zones. And the vending zones can be anywhere. And as an honourable member, you will have an input into the vending zones in your constituency. So the people you're pointing us to will not be disadvantaged unless you choose to turn a blind eye to their circumstance.
So every time a new vendor comes up, it has to be approved.
It would be that there would then be, and because we will be practical, if you have an area, let us say, for example, in the Ivy, where there are some people who may be vending and they're not at their house, but they are wherever located, then the fact of the matter is that we will want to create a vending zone so as to have proper accommodation for all of those persons who may be in that immediate area. And again, remember that the vending zone is not just about a place to put up a stall. The vending zone is intended to be an area of empowerment, so that you want to have the Wi-Fi access, you want to have the bathroom facilities, you want to have the special lighting so you can do it at night, you want to have the parking and so on. So it is really an opportunity to do vending in more commodious circumstances. It will require for some vendors to shift their location, but again, we all got to be practical about this. We can't have a vending zone at every junction. So there's got to be some give and take in the process. Agreed? Fine. Let us proceed then. Ms. Bell, the floor is yours.
Chair, moving on to clause 3.2. The following activities are not to be construed as vending for the purposes of this act. Speaks to the sale of goods and chattels pursuant to the District Auctioneers Act.
Sorry, Deputy CPC, you're either going to have to go closer to the mic or the mask because you're muffled and low.
Apologies. Yes, so clause 3.2, we are dealing now with activities that are not to be considered vending for the purposes of this act. So 2A goes into the sale of goods and chattels pursuant to the District Auctioneers Act, Cat 114, the sale of merchandise by a retailer, the sale of food or drink in a bakery, canteen operating in a club, hospital, institution, or school, club, a hospital, an institution, or a restaurant not operating on a beach, esplanade, or in a garden park, or a hotel which is not operating on a beach, esplanade, or in a garden park, whether carried on for profit or not, and the sale of merchandise where the profits thereof are used solely for charitable purpose. Provision has been made to deal with the amendment of clause 2 by order, which is unusual, but it is not unheard of. But this is because you have an anticipation that it may be that these matters would have to be adjusted. And so you're giving some flexibility to intervene without triggering the full parliamentary process. Thank you.
Are there any questions that members have with respect to Part 2? Senator Cummins.
Thank you, Chair. I just have 2 points. One, which is specific to in clause 3.1, we spoke about vending, referring to the occasional, the offering for sale of merchandise or the rendering of services. And I'm just querying if there's a reason why that language or rendering of services is not continued throughout the text, because we have here at 322, the sale of merchandise by a retailer. Is there a reason why it's not the sale of merchandise or rendering of services and rendering of services at clause 3.2b? Making sure that this language is consistent, just that query. And then I raised earlier for a request for definition as it relates to clause 2C7, hotel or which is not operating on a beach, esplanade, or in a garden or park. And you did mention in the informal discussion we had before about the NCC legislation, but I went through the Schedule 8 where it did speak about consequential legislation, and I'm not sure which specific legislation we were referring to, so I just wanted to have clarification, Chair.
CPC?
Chair, yes. So in relation to clause 3.2b, the sale of merchandise by a retailer, just important to remind everyone of what the definition of retailer would be in context: a supermarket, shop, or other entity that offers for sale or disposal merchandise to the public. And so in that sense, because of that restricted definition, that would not then be contemplating the rendering of services. So that's the first thing. The second, in relation to what the 7 relates to, this has to do with the fact that as a consequence of trying to address Great. Okay, let me start again. So in relation to clause 2C7, one of the things that needs to be realized is that the National Conservation Commission Act sought to regulate the operations of vending on the beach where which spoke to hotels. And so what needed to happen then was that there needed to be a mechanism for regulating that, to preserving that regulatory function. That regulatory function is therefore preserved in clause 5.6, but it was important to point out in clause 3.2c7 that we still want to make sure that you are not regulating hotels that are not operating on a beach, esplanade, or a park. So that is the reason why it was approached in that way. Thank you.
Any other questions? Observations? Okay. Deputy Chief, please proceed then to part 3.
Chair, are we proceeding to part 3 or are we going clause by clause? Sorry.
Sorry?
Just for clarification. For clarification, are we going clause by clause, meaning?
Yes, as you did before.
Right.
Clause by clause.
Right, but you indicated to move to part 3. We're still in part 2, and we're now.
I thought that part 3 begins at clause 4.
Okay, so now clause 4 is in part 3.
Yes, correct.
Okay, sorry about that.
No problem.
Right, so clause 4 is a licensing requirement. So vendors are required to have a license, but they are, and this is where there was supposed to be some redrafting in relation to persons they're supposed to be of a certain age and have a license. The thing is, though, from a policy perspective, starting from 16, this may be an issue under the Minors Act and also under international conventions. And so in spite of the fact that it may have been the intention to encourage entrepreneurial spirit, it may be better to say unless he is 18 years old or older and he has a license. Thank you.
Well, what are you saying specifically with regard to the let's deal with the Minors Act first and then any international commitments that we may have? What is the provision in the
Minors Act is saying that, the minor would be a person under the age of 18. Right. And under that act, you would not have the capacity to make legally binding contracts. So there is a proviso that allows for the recognition of some.
So let me just interrupt you just for clarity. So you would not be able to contract up until what age?
Right, you're supposed to be 18
Okay.
and up. So you may have to amend it to 18 and over. Thank you.
Understood. Minister Ford.
Yes, please, Chair. There's no way that we can work out something for persons who are just about 16 years old, because based on what where I sat 2018 to 2020 or so as Minister of Youth, there is an unequivocal desire for all school leavers, 16 years, we're talking 16 years when they leave school, to be entrepreneurs and business people. 60% of all school leavers. And that is a conference survey. So what I'm saying is that, can a provision not be made for those 16 years old who are interested in having their own little business to be accommodated? Somehow.
Yes, Chair. So one of the things was in the Minors Act, there was a proviso where they recognized some contracts, but that they would be voidable. So then that it can be a bit of a problem. But the other thing, the thing is that you can create probably a section, clause that would recognize the capacity to enter into those types of contracts in this context, notwithstanding the Minors Act, that is a policy issue, and there's some other issues that you may want to take into account. So I would leave it for the discussion of the committee. Thank you.
I must tell you that I'm a little bit hesitant about going too far down the wicket in this regard, because we are also talking about vendors supplying services. And I'm not entirely. Their services are wide. And as you quite rightly pointed out, already the Minors Act makes provision for some types of contract to be voidable. And they do that just because of the fact, primarily because of the fact that this 16-year-old still may need to be protected somewhat. It may well be beyond the scope of what we are intending to do here, to make alterations to the Minors Act as just a simple consequential amendment. That may require a wider degree of, a more focused degree of attention by the cabinet. We came to the 16-year. I remember the first draft. The first draft was not 16, it was 18, was it not? I think it was always 16? Well, colleagues, I think that simply put, what we've done is to have a little bit of a collision between this and another piece of legislation, which is intended to protect some young people. And an arbitrary change to that legislation is now what we would have to decide to do. Minister Ford, you wanted to...
I just want to ask a question. Are the same 16-year-olds not allowed to be employed on the contracts? I'm really trying to get it, because these same 16-year-olds that I'm speaking of, who are so interested and excited and have this fervor to be entrepreneurs and business people in this country, are the same 16-year-olds that the unemployment rates speak negatively and unfavorably as it relates to the level of employment in this country. So there's an opportunity for them to be engaged and to be involved in business, commercial enterprise. And I really put in a serious fight, because I face it, I live it, I felt it as Minister of Youth. And I know the excitement they were into paper hard. I bought all the juices from these young 16-year-olds. And they are suffering with the levels of unemployment. So I just want to know if they don't work on contracts when they are given work when they leave school, and if we can make some provision for these 16-year-olds.
Chair? Chair, as I would have indicated earlier, there is a proviso of Section 19 of the Minors Act that would give recognition, but the thing is it makes such contracts voidable, so that in any case they would in the court would, if it comes to before court, they're going to cancel it anyway because a minor is involved, right? So I'm just putting it out there, and since that is out there, then would it not just be more prudent to just have 18 years and older? But as I said, it's a policy issue. The proviso contemplates it. It is just that it's voidable. So whether or not then the other person has a legitimate claim, the court is going to void it. It's going to be voidable because of the age of the person involved.
So if I give them offer a 16-year-old contract now in my business, you're saying that if there's a situation that it goes before the court, it could be voidable because of the laws?
Right. So okay. So let me try to bring up the piece of legislation.
While you do that, Ms. Bell, the leader of the opposition had wanted the floor. Perhaps maybe while you do that, we could hear from him.
Thank you, Mr. Chairman. And I support what Minister Ford is saying. I support it strongly. He speaks about the spirit of entrepreneurship. I'm not coming from that perspective. We have a very high incidence of youth unemployment in Barbados. We have a lot of people leaving school at 16, between the age of 16 and 18. We have a big problem with youth deviance and deviancy in Barbados. The whole issue of expediency, a lot of people in St. Michael West I know who come out of very poor families, and the day they finish school, mother, grandmother, aunt wants them to involve in something legitimate. We can exclude them because of perhaps some legal consideration, but what we will find is that they will certainly be drawn into that net of deviancy. We have to address it from the other issue. I can't argue the legal perspectives here. I'm simply saying I support Minister Ford, and I understand what he's saying about entrepreneurship, but the other issues, high levels of unemployment, the whole issue of economic expediency existing at the level of households or families in Barbados, and the problem we have with youth deviance.
Before you move off on that exact same point, I was going to make the point that the Honorable Leader of the Opposition made.
You guys must be careful, you are live online.
Youth unemployment, I mean, in relation to the fact you were also agreeing with the Honorable Minister of Environment. And on a serious note, youth unemployment is a situation of young people who are looking for a job but cannot find a job, with the age range being defined by the United Nations as 15 to 24. So you are considered an unemployed youth by the United Nations, which would go towards our staggering youth unemployment figures. But at the same time, we are saying that a person who falls within that age range is denied the opportunity to be an entrepreneur. It is almost contradictory the more you think about it. But so my question, Deputy CPC, is, are we saying by virtue of what is written here that a person simply cannot be registered as a vendor, but are we depriving the person from being able to work? Because are we saying that you can continue to do this business as a vendor of sorts, but you would legally not be registered as a vendor? You wouldn't get a license, but we're not preventing the person from, like if my daughter determines that she wants to sell at 15 from my house snow cones or ice cream or something, we would not be preventing her from doing that. We're just saying legally you're not registered as a vendor.
So this is what I'm trying to draw the committee's attention to, right? We have an act on the books that speaks to whether minors can be drawn into contracts, okay? Currently, Clause 9, Section 19 of the Minors Act says, all contracts, whether by specialty or by special contract, simple contract, henceforth entered into by minors for the repayment of money lent or to be lent or goods supplied or to be supplied.
Struggling to understand.
Let me help you. All contracts, whether by specialty or by simple contract, henceforth entered into by minors for the repayment of money lent or to be lent or for goods supplied or to be supplied, other than contracts for necessaries, and all accounts stated with minors shall be absolutely void.
Sorry, Chair.
But before you intervene, Minister, let's let the Deputy CPC finish making her point.
Chair.
If you can ask
Yes.
the Deputy CPC, please, to assist the committee by speaking into the mic, because we are struggling, and asking her on each occasion that she intervenes.
Yes. Chair, yes. So then there's the proviso, provided that this act, meaning the Minors Act, shall not invalidate any contract into which a minor may, or by any existing or future enactment, or by rules of common law or equity, enter, except such as now by law are voidable. So the thing is that there is wiggle room for the recognition, but the problem is that in the public interest, it will be voidable, so that even if the other party then has a legitimate claim, it wouldn't matter because it would be voidable in the public interest. That's what I'm trying to point to. And so the question is whether then, in light of what was just read, whether it is that you can create the exception formally, or, which may be easier, just putting the age to 18 and moving forward, 18 years and over. And that's a decision that has to be made policy-wise.
Minister Cummins.
Thank you, Chair. Thank you, Chair. Now, I believe the Education Act requires children to be in school up until the age of 16. I am not clear, I'm not an attorney, but perhaps I can be advised by those in the chamber if the legislation actually does require for formal education to take place until age 18. If not, there is a gap between age 16 when a person leaves school and age 18 when they can apply for a job. And I think, Mr. Chairman, that we are talking here now about consequential amendment of the legislation, given the overall gap that is created by the education legislation and the Minors Act as described by the Deputy CBC. On that basis, Mr. Chairman, I am not sure that we should, in the context of the unemployment levels of which Minister Humphrey spoke, the agreement by the leader of the honorable leader of the opposition, and the primary point made by the Minister of Environment, who was previously Minister responsible for youth, that we should in policy have a situation continue where there are 2 years in legislation where 16 to 18-year-olds are not required to be in school, but they cannot legally be employed or engaged in any kind of employment type relationship. And so, Mr. Chairman, I would want to recommend that the legislation, in fact, as it is drafted now, remain at 16, and perhaps under the context of consequential legislation amendments that you and perhaps the other affected ministers may wish to raise, that the substantive legislation may in itself need to be amended to so allow for that.
Here's what's going to happen, folks, because I think that the CPC has given us a very sound exposition on the law and pointed us into the fact that there is a proviso that can be applied, but that we should walk cautiously when applying that proviso. And the committee, in my judgment, must be careful not to engage in whimsical conduct. So that I would want to urge, therefore, that we take advice from the Ministry of Youth Affairs on this matter, and equally so from the Solicitor General, and that we ask them to come back to us in the shortest possible amount of time. And then on the basis of that very solid sourced advice, we will be able to make the decision as to whether we move this from 16 or not. I wouldn't want for the committee to undertake that venture without the benefit of the best possible advice. Otherwise, we would be acting on a frolic of our own, and I don't think that is appropriate. CPC, please then proceed. Mr. Clerk, would you have the necessary letters sent off at the earliest possible opportunity to both the Ministry of Youth Affairs and also to the Office of the Solicitor General? You are at 4-2, ma'am.
Chair, so for one, then requires the age discussion, and then you are required to have a license to operate as a vendor in the circumstances as set out in 3. Clause 4.2 states that if you are in contravention of Clause 1, Clause 4.1, then you will be subject to an administrative penalty. Clause 5 gets into the application for the grant of the license, and I would, at this point, then invite comments in relation to this matter, this particular provision. Thank you.
You're inviting comments on Clause 5?
Yes, Chair. Also, in relation to just one of the policy matters, so it's fresh meat was supposed to be covered under the vending legislation, so that there were some
under which legislation?
Under the vending legislation, which is
Right.
what we're considering here.
Right.
As a consequence, then, there were some amendments to be done to the Markets and Slaughterhouses Act. Inadvertently, there were some provisions that were left out, and that's Part 2, Part 3, and 8 of the Markets and Slaughterhouses Act were supposed to be taken out as a consequence, because we're trying to deal with vending here in this legislation. So I just wanted to flag that. And so in the subsequent draft that would be submitted for next week's consideration, then those particular amendments will be put back into the consequential amendments, and that will be in Part 8 of the bill. Thank you.
I didn't hear the last couple words you said. That would be part what of what?
Part 8 deals with the consequential amendments.
Okay, yes.
Yes.
Fine. So that beyond the, yes, you could disconnect that, please. They're all mine. Beyond the consequential amendments, I think, colleagues, what the Deputy CPC is now inviting, therefore, is our views on Clause 5 in its entirety. Now, we had gone through this we've gone through this at the start of the morning when we did the broad overview of the legislation. Are there any issues that any members have with respect to Clause 5?
Chair, I'm trying hard to identify a section where the minister refuses to certify an application. The matter can be reported to a judge. I'm looking for it, and I'm wondering if we would do everything that we can to keep these matters out of the court system unnecessarily, when most of these matters can be resolved. They're not that seriously contentious that they must end up before the court. I personally believe that a mechanism could be put in place where if the minister makes such a decision, a provision could be inserted that would allow the individual to apply to a special committee or tribunal within that could receive the matter. Is it in there?
Honourable member, I say for the benefit of other members who may have felt that this morning's exercise was overly pedantic. This is precisely why it was conducted.
Yeah.
There is, we are going to come to that, honourable member. We are going to come to that. Keep your powder dry. Keep your powder dry.
Sorry.
I think at this stage,
No, I escaped for a little while.
at this stage, we are at the point of determining the process of application for the grant of license. Deputy Chief, it might be easier to tease out any concerns if you just went through this once again.
Chair, hopefully you can hear. Sorry, I'm so sorry. Chair, yes, so generally the Clause 5 deals with the procedure for the applying for a grant of a license. There are two regimes going on here. Applying for a license in the context where you're not vending in a beach or esplanade or garden or park, okay? And so then you would have to submit an application form to the minister, okay? And the minister in this context would be the minister responsible for commerce, okay? And so that's 1 and 2. So in the 1, you're dealing with those vendors who are not operating within the esplanade or garden or park, right? and they would be required to submit an application form, proof of identification, proof of address. If you intend to operate as a food vendor, then you have to show a certificate of good health by a registered medical practitioner, a license to carry on a food business, and then those who are seeking to operate outside of the public market, they have, as a meat vendor, they have to then show that their meat shop or premises is in a certain type of condition. The minister then, under clause 5.2, on consultation with the minister responsible for public markets and the minister responsible for fisheries, would grant a license to an applicant referred to in subsection 1. Then we come to the licensing regime, which deals with the persons who intend to vend on a beach, esplanade, garden, or park. They would then have to apply to the NCC, and they would be submitting an application form, proof of identification, proof of address. If you're operating as a food vendor, the health certificate, your license to operate a food business, for the health services and food hygiene regulations, and also the payment of a fee. The fee is also applicable in the first case. And then for the National Conservation Commission may grant a license to the applicant referred to in 3. Then in 5, you have where a person who submits misleading information in their application, then they will be subject to payment of an admin penalty. And then the next provision all stipulates that 3 and 4, which deals with vending on the beach, and if they're a hotel or a restaurant or other business, they would have to apply for, they would have to apply as well, and they have to show that they have a valid license under the Liquor Licenses Act. So that is clause 5.
Minister Ford.
I just want to ask a question. Is there any provisions in this legislation that speaks to the proof of the source of the goods? Because oftentimes we hear that farmers and other persons, they lose their stock. And is this your license subject to prove, for you to prove that your source of goods is a legitimate source? Is there any provisions for that?
In order for you to
sell product?
No, but okay. You have a separate regime that regulates transactions. That's a separate regime. So that is going to be dealt with then under the Protection of Agricultural Products Bill. Separate regime where you're regulating the transaction itself, and at that point you would have to then show where things came from, etc. So that is a completely separate regime. Sorry.
Mr. Chairman?
I caught the leader of the opposition first, but you are next, Senator.
Okay, thank you.
Leader of the opposition, the floor is yours. The leader of the opposition prefers to give way to you, Senator.
Thank you. I've always known him to be a gentleman. Thank you very much, sir. Question through you, Chair, to the deputy. Based on her intervention earlier, I want to have an understanding of the process. And only because of something you said. Is it that the applicant to the NCC and or the minister responsible for public markets and so on will apply there, and they'll get their license to operate from those two entities following consultation with the Minister of Commerce? Did I hear that in terms of the process?
So, yes, Chair. Okay, so there are two regimes. There is a regime where that regulates when you're vending from a beach, park, esplanade, etc. And that is regulated by the NCC. But if you are selling outside of those zones, then you will apply to the Minister of Commerce. But then in the grant of the license, the Minister of Commerce would have to consult with the Minister responsible for fisheries and the Minister responsible for public markets, given the fact that there are some overlapping jurisdiction, and they should have some input in how the license is granted. Thank you.
Chair, it is that word consult that I thought I heard earlier, and that goes to process. And we all know, all of us in the chamber knows that, Chair, these processes can at times be long and arduous, and can at times be at the disadvantage of the applicant. So Chair, I'm wondering if there is a way that the legislation can enable a process that allows for the Minister of Commerce, in the instance where the applicant applies there, who can issue that license and maybe communicate to the other areas, the other ministries, following that submission with the proviso that it can be revoked if there's something untoward that the due diligence suggests. And Chair, it's only because, or if there can be another simpler way, because I'm conscious, sir, that we're talking about, persons who want to maximize on whatever opportunity it is. We all know in business, time is money. And so, we want to avoid in this modern time these long and unnecessary bureaucratic processes.
Senator Holder, this matter, I would have to say to you, was perhaps the most challenging of the areas that we confronted in the process of bringing this legislation. There is a separate regime, completely separate, standing on its own, which the Ministry of the Environment had for dealing with the beaches. Equally, the fish markets are governed by their own regime, and everything else in Barbados is considered a market to be governed by the Markets and Slaughterhouse Act under the Ministry of Agriculture. So it really became a challenge to try to bring these three together into one unit. I understand what you're saying. It is perhaps the best that we can make of the circumstances to have it done in the way that we are doing it, because effectively what we want to do is to have one piece of legislation which ensures equality of treatment across multiple theaters of commercial activity. And each of those theaters of commercial activity had previously been governed by its own rules and regulations. So we're trying to bring them together in one. I understand clearly the challenge you have, because it is a matter that I had turned over in my mind as well. I believe that when we speak about consultation, it should be understood that it is not just about minister to minister consulting, but rather the principle, I can't remember, was it Wins? Was it the
Carl Toner principle?
Carl Toner principle, that ensures that it is really the staff of the ministry who do this interfacing. And effectively what would be happening is that the ministry responsible for fisheries and the ministry responsible for fisheries alone will be in a position to say there are 4 available stalls at Oysters Fish Market and 1 at Paynes Bay. Nobody else can determine that. And therefore it is for the Ministry of Commerce to reach out to say, we have applications, can you fill the space? Or can the space, is there space for the applicants to be satisfied? And it is only then, when once that consultation is done, that you know what exists within the Ministry of Fisheries. It is not an automatic thing, therefore, that if all of the fish market stalls and so on are taken up at present, and you have 5 applicants to have a fish market stall, that you could automatically get it. That is the reality, and the only way that that could be governed really is by the ministry responsible for fisheries making that determination. So too it is with the National Conservation Commission. Because they must maintain the beaches in a certain way, and because they have a certain responsibility for the environment and all the other things related to the management of the beaches, flora and fauna, they must be in a position to say this is the amount of space we're allocating on any beach for vending. And the only way that we can know that from Commerce is by interfacing with them at the staff level. So I understand the challenge, but really it is really the only, up to this point, the only feasible way of operationalizing this that we've been able to come up with.
So, Chair, follow-up, is it a case where the applicant then applies to the ministry, for example, in this case, of the environment and or markets and so on, and those ministries issue the license, and those ministries then in turn notifies the Ministry of Commerce? Is that the process?
Yeah.
Chair, no, you apply to the Minister of Commerce, and then when there is a decision to grant, but there must be a consultation with the Minister responsible for fisheries and the Minister responsible for public markets. That's how it's supposed to work.
And at the back end of that, obviously the ministries outside of commerce, fisheries and environment must be able to keep commerce abreast of what are the licenses issued, so that we are able to maintain the register properly.
And Chair, just to be very clear, you have to recognize the 2 regimes that are being regulated here. There's the regime where you're dealing with the parks, esplanades, etc. That is dealt with by the NCC alone. But where you're outside of that, then that is dealt with by the minister responsible for commerce. But then in the approval or the granting of the license, he still must have some consultation. He must have consultation with the minister responsible for fisheries and the minister responsible for public markets. Thank you.
Mr. Chair, could we put in a mechanism in the legislation that says that where the interests of 2 departments, 2 ministries, not necessarily come in conflict, but converge. Correct, thanks very much. Converge, that there would be a mechanism that would allow a kind of interministerial or interdepartmental committee to be able to, can you do that in legislation?
Chair, just to say that originally it used to be consultation with the vending committee, and then there was a long discussion. And you see, the thing is that what we have here is as a result of prolonged discussions by stakeholders. Admittedly, it is not perfect, but we don't want the perfect to be the enemy of the good. In addition, I have to make the observation that the Act does not come into effect immediately, but that there is provision for it to come into operation on the day of proclamation. That then gives all the functionaries the opportunity to come up with a mechanism that will deal with things as efficiently as possible. Thank you.
Leader of the opposition.
Thank you, sir. No, this the money is not big, but in my view, the principle, PLE, is big. And I do not know why we continue to attach fees to things like this. I said this before. I understand if we ask very affluent lawyers to pay a professional fee for to be allowed to operate on a yearly basis, or the medical people or what have you. I understand that. I do not understand why we're asking vendors still in 2021 to pay a fee. Money is small, but to me the principle is a big thing. I understand the penalties for breaches, and they should be applied, but a license fee to sell pears down the road at the corner, certainly that is that's behind us. Government can't make much money from that. Well, what's the fee for?
Minister Cummins?
Chairman, thank you. I just wanted to raise a point here in the licensing application process. Now, the legislation does speak to, in great detail, the information required for the licensing, what happens in the issuance of that license, and what happens in the instance of breaches. But I am not seeing any requirement for an obligation on the part of the government agencies of which you spoke to turn this around in a time frame that does justice to the applicant. So, Mr. Chairman, if we are to have persons who have submitted an application for a license and they're there for the purpose of earning a living and their livelihood, and they're not those that are earning significant sums of money on a monthly basis, if they're paying an application fee of $150, Chair, and this takes, as is unfortunately not unusual in the system of the bureaucracy, to take over an extended period of time, I think then that creates a challenge. And Mr. Chairman, I would want to urge perhaps that we would want to have at least some level of predictability given to turnaround time for this in the interest of applicants, Chair.
And may God bless you for that, Minister. I know that this is a matter that also attracted our attention earlier, and I'm glad that I'm not alone. I feel that this is perhaps, and I will come back to the Leader of the Opposition, but I feel that this is perhaps a matter that we could benefit from some guidance on as to how best this check and balance on the system could be implemented. Because with the best wishes in the world, unless there's some sort of at a minimum, an agreement that there is an standard of service arrangement between the two ministries or the three ministries, there is that almost predictable and inevitable challenge that we will come up against, whereby something would just take too long on somebody's desk at some point in the process, to the detriment of an applicant. And I'd be happy to hear any suggestions as to how we could get around that. The Leader of the Opposition is speaking before having the floor, but I'm happy to hear him. On your other point, Leader of the Opposition, the legislation, I know, to be fair to you, you made the point about fees when you spoke in the House when this matter was introduced. I felt then, as I do now, that it is an interesting point. The register of vendors, which we will come to at Clause 7, has to be created and it has to be maintained. It will be done in electronic form and also in physical form. To the extent that it is going to be in physical form, it will require some manual work. And I think that basically we are talking about a nominal fee, but effectively one has to have manpower to do these things. Now, I'm not going to say that the $100 that is being charged for an annual license, or the $25 or $50, whichever it is, for an occasional license, is adequately or accurately reflecting what you're going to pay somebody to maintain the register. But equally, in my judgment, precisely because it is small, it does not do harm or injury to the applicant. But at the same time, everyone who has to pay a cent in anything takes a stake in the process. And I think that that is also an important thing as well. And that is, but I'm prepared, Honorable Member, to hear your argument on this further if you wish to come back again. Deputy Chief, are there any suggestions that you can make to us on the point that Minister Cummings raised? Please.
Chair, a time period could be inserted in terms of the decision to make for the grant of a license. So it would just be a discussion, a policy point in relation to the time period that can be set. So is it 7 days? Is it 14 days? What is in the interest of business, but also balancing what are the resources of the ministries involved, all the functionaries involved in order to get that job done? Thank you.
And I am reluctant to arbitrarily try to set a time frame from this position, but I would be grateful, Minister Ford and Minister Humphrey and Minister Weir, if you all would speak with your technical chiefs and get an idea as to what they feel would be a reasonable turnaround time.
Minister, Chair, just to be clear, there are going to be circumstances where the response is we have no space. You know, that more often than not will be the response. If persons apply, for example, in the fish market, there are hardly any spaces. People often want to be selling fish, especially we found a tremendous increase in the last year because circumstances were so hard. But the response would be, we really don't have any space. I do not know in those circumstances that persons should pay an application fee when we clearly don't have any space. What happens now normally is that persons only pay a fee when we are offering a space, not necessarily on the application itself. So verbally you say, oh, sorry, we don't have any space. Once such is done and there's actually a facility to actually have somebody, then we say, well, this is the fee, this is what you have to pay, and so on going forward. So the response time, for me, could be very quick, because more often than not, I'm saying, I do not have a space. If it is a case where there is a space, then, and we're offering the person a position in the market, then we would then be able to set a time frame.
And I think that's what we need, the time frame for the, because in the negative, it really is not an issue.
Yeah.
You can set that immediately, because you know.
Yeah.
If the affirmative is the issue, then we would need to know what, from your ministry's perspective, are the considerations.
I'm agreeing with you, Chair. I'm just saying, in practice, instead of taking people's money for application, so that people are applying and there's no space, that seems somewhat.
No, you argued two things at one time, and I take the second point as well. Effectively, if I'm understanding you correctly, you're saying that, and the Leader of the Opposition is not listening. I want him to listen. The suggestion from Minister Humphrey is that you would not charge a fee to someone who is not going to have an affirmative answer to the application. But you know, the opposition is going further.
Yeah, I know where he's going. I wasn't responding or trying to rebut what he's saying. I'm sure what he's saying, it comes from a very decent place. But all I'm saying is that the current practice now is that that person only pays once we are in a position to give them a space. And that was more in relation to the Minister Cummings' questions in terms of time frame and so on. So I take your point that on the one hand where there is no space and the response is almost immediate, but does that response then come from you, Minister of Commerce, or from me, Minister of Maritime? And that ties me into the issue that Senator Holder raised, because I don't think we want to create systems that unnecessarily become more and more convoluted. You know, the Prime Minister were here, she would speak of the Byzantine architecture that we seem to build. The way I had envisioned this thing, Chair, would be, because beyond an application, a person is determined to get a space if they're trained to a certain extent, so that the person has the skills to be there in the first place. We were looking at some point at person's behavior, if the persons had a history of causing disturbances in the market and so on. So I'm saying there are other things that come to bear beyond issuing a license that Commerce would surely not be aware of. And I had thought that the way this would work would be that the person would come to us. We would do the necessary, this is how I thought it would work. We would do the necessary work and make the recommendation to Commerce, so that Commerce's only responsibility would be to assume obviously that we've done the work, and then we pass it on to you, issue the license, you keep the register, because that would be on that end. I do not know that you want to inherit the work of actually investigating all these persons on a case-by-case basis.
No.
That work remains with the ministry, and at the end of that work, we say, okay, we are going to recommend you for the license from the Minister of Commerce, so that you have your files, you have your records, but you're not, getting involved in the minutiae of the ministry.
No, I think you're getting a little bit lost here, because all of that is supposed to be captured in the consultation process.
Yeah, I don't think I'm lost. I think you're lost. What I'm saying is, I'm far from lost. What I'm saying is, Chair, that in terms of consultation, why would the Ministry of Commerce wish to engage itself in these matters that could easily solely be determined by one ministry? Why then would we have to go and make this process so complex? Why can't the ministry with the skills, the know-how, the relationship, make the assessment and make a recommendation? The consultation then becomes between the Ministry of Maritime and the Ministry of Commerce. But I don't know that you want to engage every single vendor.
Deputy Chief, you're leaving us? I think that it is within the. I was looking for it in the legislation. I think that there is a provision in the legislation for there to be a register maintained of all of the vendors. I think it is 7. Yeah. So that at clause 7, that provision for the register is there, and that register is maintained by the Ministry of Commerce. I believe that where Ms. Bell was going is that once you have done all of your due diligence internally, and you've issued or agreed to the issuance of the license, then the register that reflects the fact that the license has been issued has to be maintained which is obviously a question of us facilitating each other with the flow of exchange of information.
Chair Evermere, Chair. What I'm gathering is that from the legislation is that because we are having one vending bill, and you as Minister of Commerce, that this is what you're getting from the legislation, that persons apply to the Ministry of Commerce in the event that it is an application that would require the visual acuity of either myself as Minister responsible for NCC, Minister Humphrey, or Minister in the area based on where the person seeks to vend. I think that what Ms. Bell was saying is that there's a central ministry, which is the Ministry of Commerce, and then you would pass on that application to the various ministries. That's why I'm saying that the legislation is speaking to, rather than individual persons applying to individual ministries. That's why I'm saying.
Yeah, yes. Except for the ministry that you lead, Minister, I believe that in the case of the ministry, right, the National Conservation Commission, because of its unique responsibilities, has the complete control over that. But equally, then you all share with us that information with respect to issued licenses. Minister Cummins.
Chairman, thank you. I take the points raised by the colleagues, Minister Humphrey and Minister Ford, and of course your explanation and that of Mrs. Bell. But I just want to perhaps offer a bit of a counter to some of what we're thinking. So from a regulator's perspective and from an administrator's perspective, what we are doing functionally works. Whether it is a consultative mechanism, whether it is the individual ministries who have the relationships leading, from an administrator's perspective, it's fine. But I want us to pause for a minute and think about it from a user's perspective. Is it overly burdensome to the user to have to go through what could be perceived to be a bureaucratic process when perhaps we have an opportunity in 2022 to craft a process that enables the user to have an efficient engagement with a one government approach, where we rationalize where the information needs to come from, but the user has just to have one single interface. I think if we were designing this maybe in the early 2000s or late 1990s, we could perhaps take a different approach, but we have an opportunity close to the end of 2021 and the beginning of 2022 to modernize some of these processes in the interest of users of the system. Because, Mr. Chairman, I have to say that oftentimes the comfort of a salaried job clouds judgment when $150 has been shelled out for an application process and you are waiting for an extended period of time to get an answer. That seems like a lot of money, not just money spent, but money lost in the interim. And it also makes criminals of people who are really just trying to earn a living, not because we want it to be so, but because we could have had an opportunity to make it user-friendly. And I just want to perhaps go back to the earlier recommendation that among the agencies affected, there may need to be a discussion on what that time frame would look like, but also to layer on top of that, Chairman, what the process should look like to make it user-friendly and as simple as possible.
And the point is taken, Minister. I must tell you that Clark and I were exchanging similar conversation here at the table. What probably we have to decide, first of all, is the time frame within which the user gets an answer if it is in the affirmative. And I must tell you, I genuinely can't, I don't know what happens in agriculture, I do not know what happens in fisheries or equally at NCC in this regard, but it would seem to me that a week should be an outer limit. I really can't envisage why it should take much longer than a week. And in the case of you, Minister Humphrey, you would know where your fish markets are, and you would know what capacity you have. Either you have or you don't have. So it shouldn't be that hard. So a week might be even too long. But I mean, you know, I don't want to just sit here and say that glibly. I feel that, Minister Ford, you're agreeing with me or disagreeing? Your mic is not on.
I'm saying that I suspect those questions will be answered by the various entities that we can revert as soon as. Yeah.
Oh, the manager markets is present. Would you be willing to assist us, sir? Before you speak, let me just alert the members of the committee. It is my proposal, it is now 10 past the hour. My proposal was that we would take the luncheon interval at 15:15. We may, depending on how much conversation is triggered by the manager markets, have to push that back a little bit. But that is not meant to shorten your contribution at all, sir. But we will go to lunch for 45 minutes and then come back and do another hour to hour and 15 minutes before we close for the day. Please proceed.
Mr. Chairman, it all depends on the type of activity.
Sorry, state your name and your position for the record,
Manager
please.
Markets, Minister of Agriculture. It all depends in terms of the activity that you're looking at doing. Some activities require some background information to go through the police or whatever the case may be. Some activities you have to make a decision on the spot. I would have explained that you have perishable commodities. You are a farmer, your commodities are perishable. You come across, you have a bananas, fruits, whatever the case may be. You cannot wait for a week or 2 weeks for a decision. As it stands, if a person comes to a public market, he has some commodities, and there is space, you make the decision on the spot to allow that person to sell. Okay? If you are if you're a butcher, you're applying for, you're looking to get a butcher's license, you have to go through a series of steps, health regulations and so on. If you want to sell food, again, the food hygiene regulations are there, which would require some investigation. The person may have to go through different things. And the fish markets again. You may have a situation where a person who have decided that, okay, I'm going out to fish. You catch a whole set of jacks. You can't wait till a 2-week period because the commodity is inherently perishable. So the decision, as I agree with the Minister of Maritime Affairs, that I understand what your intentions are as well with respect to the bill, but there are unique situations within the fish market setting, and he knows quite well that we're trying to do some work with the vendors and so on to improve the SPS measures and so on, which will require a duration of time and some training. The same thing happens with those persons who are involved in meat vending as well. So again, for a person who wants to sell food from a canteen, a week or 2 weeks might be enough, but a person who has highly perishable commodities, time is of the essence, and as Minister Cummings has rightly said, that you do not try to make have a person jump through too many hurdles in order to make an honest living, because some person may have a pressing situation at hand and will want to get involved in a business activity as quickly as possible.
But Cheryl, I'm sorry, this is Mr. King. Surely then you're pointing us to a zone where we have to find some reasonableness. It can be fairly short in some instances, or it could extend for over a week in others. And we got to find a way of finding a sweet spot somewhere in the middle, where it'd be a best practice that we'd be aiming at getting everybody to come to. If you had, and I'm not holding you to this now, but just to advise the committee, if you had to advise the committee on where you felt that reasonable zone across the ministries would be, where would you say? Time. The time frame. How long?
No more than a week.
A week.
In my view, because if there is space available within a particular market, and you can get all the players involved, if you have a large committee, it has to go through a host of other people, you know that that's going to be problematic.
Right.
If you have a very, very small committee, or that you can run robin rather quickly, you can have a decision within a week or so.
And the way I see it, to be honest with you, Mr. King, is that my Director of Commerce or the Chief Business Development Officer contacts you or contacts your counterpart in fisheries, or alternatively Mr. Alls, and that is really the committee. Mr. Alls at NCC, Mr. Lewis from fisheries, yourself, or Mr. Kalmach. Effectively, in some instances, that is no more than a phone call. And if there was even if there was need for collaboration across the four of you, you can do that on a Zoom meeting for a couple minutes. It is not that difficult. So I'm thinking that, we should be able to say at the outer limit that a decision is taken of this nature within a few days. 7 days, in my judgment, is more than enough.
But Minister, you also take into consideration that some activities require a level of investigation.
Agreed.
Okay,
Agreed.
And in some instances, from our standpoint, let me for argument's sake with the police, the Royal Barbados Police Force, sometimes the applicant can be protracted because of a number of things. The police may want to see the physical area. They may want to make sure that there are no obstructions, you're not blocking. Then there's also the aspect of the fire service as well. And as you know, in the market system, those issues do not exist. But as you start to go in outdoor vending spaces, on streets and highways and so on, you have to take a different approach in terms of how we're going to do the approval of the applicant. And again, the nature of the activity, as long as you start going to prepared food, processed food, and so on, the requirements are, again, different. You have to you know,
For
go
this
through
health and
different.
safety considerations.
Precisely.
Yeah. Okay, fair enough.
Chairman?
Yes, Senator Wiggins.
Yes, sir. Thank you. I want to introduce a new ball here right now.
You want to do what?
I
Sorry?
want to introduce a new ball here right now.
A new ball.
Yes, sir.
A new ball is never a good thing to introduce just before lunch.
So, given that we are talking about the regulations for the licensing requirements, I was wondering, even in a little bit of segue, moving on from what the manager of markets was saying, that if you're going to be doing background checks and investigations, and you're regulating vending and you're regulating these activities, where would we put predial larceny? Because you want to more or less, you know, regulate the whole aspect. Because a lot of vendors, you know, before you can take your produce to the supermarkets and so on, you have to have a license and possibly a receipt to show the source where you have gotten the produce from. So I'm just wondering if this would also be a good mechanism to control the whole question of predial larceny, even in terms of granting licenses, as well as to approve, because the manager markets is saying a week. And suppose if the police or Ministry of Commerce through here is investigating and there are issues of predial larceny, if it wouldn't take a little bit longer, sir. So that's the end of my bowling spell, sir.
I understand. You may have changed games. You may have actually gone to baseball and introduced a curveball. But but I think that we can allow Minister Ware to speak. He can choose either before or after the luncheon interval. But his ministry is working on another piece of legislation which will treat to this matter, as I understand it. You want to go, Minister?
Yes, Chair, thanks. I'll be very brief. Deputy Chief CPC already alluded to it earlier. This is under a separate regime, really. And the legislation itself is highly modernized with technology, so that within the space of hours, you can get information on anybody with produce.
All right.
Chair, may I have one quick second?
Minister Humphrey.
Sir. Okay, I just want to get the process right. We brought a bill here last week, or 2 weeks ago, on the FAL, where every intention of FAL is to have, as we are seeking here to do, you submit from the ships, international ships, one time, and then through an electronic process, the various agencies responsible for information get it. It's almost on time. Basically, these things happen immediately to facilitate international ships and international business, and hopefully to move our marking up the doing business index. In this circumstance, we too must be seeking to facilitate business. We're seeking to facilitate the vendors and to make them have an experience now that is quicker, it is seamless, it is less painful, less bureaucratic. And I appreciate that we need to have a single repository of information, which is commerce, and I totally support it, as I've always supported it. But I think we have to be very clear that the process is, as you're seeking to do, sir, expeditious and not challenging on the persons, because my whole focus was simply that I'm thinking that because we know our people and we know the circumstances, it would have been easier to work the other way. But if it's coming from you, we would then have to be, commerce would have to be, as markets, as fisheries, would have to be very, very clear that as soon as the application comes in, it would have been nice in a situation similar to FAL, where that information is shared almost immediately, because we've built a whole architecture to facilitate the ship. So the application comes in to the Ministry of Commerce. It then has to go to an officer who then has to contact the person, bear in mind that the person knows nobody in commerce. Then they have to contact an officer in maritime, who's probably going to be a senior officer, who has to go and contact the lower level officer. I just think, Chair, when we think this through, and I agree entirely, it goes to one repository. I'm not challenging that at all. But we have to put as much effort into building that system to ensure that this does not take unnecessarily long, because I'm telling you, as it stands, we've added about 2 layers almost of additional bureaucracy that currently do not exist. And it is oftentimes very difficult to appreciate that adding bureaucracy expedites anything. So I am just saying we have to be very clear in our step-by-step deconstruct and reconstruct. We know those words well. And just be sure that what we've done actually makes it easier on the vendors while we try to make it easier on the government, because we're seeking to make sure we have this repository and that the government is clear about its business, but we have to be clear that the persons for whom we are seeking to offer a service feels the improvement in the service that we offer. So as I close, when I used to be head of the constituency councils, we created a system very similar to this. Every constituency council had a go-to person in every ministry, so that in the hope that you would facilitate business. But what we found was that those persons never felt that that was the work of their ministry. So many times, so that in welfare you had a go-to person, in NAB you had a go-to person, but when you contact your go-to person, it's like, I'm busy with other stuff. Mm-hmm. So in practical terms, because fisheries really and truly is not the work of commerce.
Agreed.
And I do not want it to be a situation where it is seen as a 2 or 3 tiers down, so that when we build this out, we just have to be very, very, very clear that it is given the kind of priority that it needs, or this conversation about 6 days and 7 days might just be theoretical.
Mr. Chairman?
That's a very good point. And I would want us to be able to reflect on it. Senator Holder, you wanted the floor?
Yes, sir. I thought that you agreed there's at least one more over with the old ball. Minister Humphrey, board, I think 3? Yeah, there's 6, right? Okay, I'll take the other 3. Chair, I want to support Minister Humphrey's intervention wholeheartedly. And I guess because I raised this earlier, the issue of process. Sir, can it not be a situation where the applicant applies yes to the relevant ministry, NCC, markets, fisheries, and those ministries issue the license, and the ministry in turn then simply communicates with Commerce to have the register updated and kept current, instead of the other way around? Sir, I'm very conscious of the user here and representing some of the users. You know, we want to have a nimble process. So couldn't that be contemplated, sir?
At first blush, I would say it sounds as though it could be. Maybe what we should do is to let us just reflect on this over the lunch. I think Ms. Bell, no, I say that seriously because I think Ms. Bell may need to have a conversation with me as well on this. You all, many of you do not know, but this went through countless iterations. And Mr. Cumberbatch, I ain't gonna trouble you to speak now, but you were in it from the very get-go. And the policy consideration is something that, the original policy consideration is something that I would be glad to hear from you on. So that maybe what we probably should do, in fairness to you, Senator Holder, and you, Minister Humphrey, is let us just take lunch, have the conversations among ourselves, and come back and see whether we've been able to wrestle this to the ground. All right? It is now 1:25, and I would propose, pardon? Sorry. Well, clerk is advising me that it's closer to 1:30. And I would propose, I propose that we come back at 10 minutes after 2. 40 minutes. I don't know that we need to have full 45. Lunch is in the customary dining room downstairs. Okay? Okay, so at 10 minutes after 2, I'll be ready to reconvene. I would hope that we have the necessary quorum. at 10 minutes after 2. Thank you very much. We are adjourned.